Think about the last time that you booked a flight or a hotel online. Did you read every word of the terms and conditions first? Probably not. Most people search, compare prices, and they finish their booking. Yet, that website may claim that somewhere in the process, they accepted a legally binding contract. So when can Priceline actually hold a customer to its online terms? First, I want to call attention to the fact that there is a difference between this assignment and Priceline's current website. The assignment refers to Part 1, Sections A through F, but the agreement that I looked at now has 11 numbered sections, including newer provisions about AI, Priceline's Penny Assistant, and AI agents. Due to this change, my focus will be on Section 1 on acceptance and updates, Section 9 on warranties, intellectual property, liability, and indemnity, and Section 10 on disputes. I'm going to attempt to answer 4 valid questions. Can these terms form a valid contract? Should visiting the website be enough to bind somebody? Can a customer sue Priceline? And what should Priceline change? Well, let's find out. First, is Priceline's user agreement a valid contract? Yes, it can be, but not just because Priceline calls it binding. The Federal E-Sign Act says that a contract cannot be denied legal effect solely because it is electronic, and Connecticut's Uniform Electronic Transactions Act follows the same rule. Electronic contracts are real contracts. The normal requirements still apply: an offer, reasonable notice, objective agreement or assent, consideration, legal capacity, and lawful subject matter. Priceline supplies booking tools and services. Customers make promises and, when booking, provide payment. The likely dispute is acceptance, really. What point did the customer see, and what action actually showed agreement? Priceline Section 1 says accessing or using its channels means agreement, and it treats continued use after posted revisions as acceptance. A court would still like to examine the screening design, link placement, warning, and user action. So should you have to agree to the terms? Should visitors be bound without clicking I agree? For arbitration, jury, and class action waivers and liability limits, ordinary browsing should not be enough. A footer link plus access means acceptance is passive notice. It gives Priceline weaker evidence than affirmative choices. The case really showed the difference. In Spect versus Netscape, users could download software without seeing terms placed below the button, so the terms were not enforced. In Mayer, linked terms appeared beside register, and registration clearly communicated agreement, so the court enforced them. In Berman versus Freedom Financial Network, a tiny gray notice beside continue was not enough, because clicking continue did not clearly mean I agree. User research explains why design matters, too. Jonathan Obar and Ann Oldorf Hirsch studied 543 participants. 74% used quick join and skip policies. 98% missed at least one extreme gotcha clause. So this means a checkbox cannot prove someone read every word, but it strongly supports clear notice and deliberate agreement. So can you sue Priceline over a dispute? Can a customer sue Priceline? Yes, a customer can bring a claim, but valid arbitration usually changes where and how it's decided. Section 10 first requires written notice with the required information sent by email or regular mail, followed by a 60-day informal resolution period. That step is required before arbitration. A dispute also generally must be brought within 2 years unless applicable law prohibits that deadline. The filing clock pauses during the informal process as well. Unless the customer opted out within 30 days of first becoming subject to arbitration, most unresolved disputes move to individual arbitration through the American Arbitration Association, or AAA. Arbitration is a private process outside ordinary court, governed here by the Federal Arbitration Act. Both sides waive a jury and class representative proceedings, and one arbiter generally decides the dispute. In AT&T Mobility versus Concepcion, the Supreme Court made a valid individual arbitration clause difficult to defeat merely because state policy disfavors class waivers. Federal law may override that rule, though. But Concepcion does not remove Priceline's duty to prove agreement. The claim survives, but valid arbitration usually removes ordinary courts, a jury, and class procedures typically. So what else should Priceline change? Section 9 contains legitimate protections, yet some go too far. Section 9.8 excludes broad categories of losses and generally caps liability at the total charge Priceline assessed for the booking. Section 9.9 contains indemnity, meaning a user may have to cover certain claims, losses, or legal costs. It reaches agreement breaches, violation of law or third-party rights, misuse of Priceline channels, and use of penny-generated content. Priceline should keep reasonable warranty limits and its ownership, copyright, trademark, and Digital Millennium Copyright Act procedures. It should also preserve rights that cannot legally be waived and remain responsible for its own fraud, willful misconduct, gross negligence, and serious scrutiny failures. User indemnity should cover only third-party claims caused by a material breach or unlawful conduct. The copyright section should explain DMCA counter notice rights as clearly as takedown notices. Priceline also needs better change controls. Section 1 says revised terms may take effect when posted, and continued use means acceptance. Section 10.3.11 promises notice of material arbitration changes, but continued use still counts as acceptance, and a customer who previously failed to opt out will not receive a new opt-out opportunity. So here's the final answers. Can Priceline's agreement be valid? Yes, but Priceline must prove reasonable notice and agreement. Should browsing alone bind visitors to high-stake terms? Priceline says it does, but clear click wrap before account creation and booking is a much stronger idea. Can a customer sue? Well, a claim can be brought, but valid arbitration usually moves it to an individual private process. The 30-day opt-out, small claims option, intellectual property exception, and formation challenges still matter, though. So what should change? Priceline should use provable click wrap, separately warning users about arbitration, preserve consent records, narrow liability and indemnity, explain DMCA counter notice rights, and require a transparent, forward-looking agreement to major revisions. That conclusion is supported by Priceline's current agreement, the E-Sign and Federal Arbitration Act, Connecticut law, courts deciding and enforcing and rejecting online terms, Singer v. Priceline, Professor Goldman, the Electronic Frontier Foundation, the Digital Media Law Project, and empirical research on user behavior. The goal is not to eliminate the user agreement, it's to make fairer, clearer, and easier to defend. Proving what a customer saw and deliberately accepted is far stronger than just hoping a footer link was enough. Thank you.